Okay, good afternoon. It's Tuesday, just after 2 p.m. and it's time for question time with the party wall guy. Lightly different studio today, so you might hear some extra echoes, but let's get going. So welcome. Okay, quick introduction. My name is Dale Gujral. I'm the party wall guy, and every Tuesday after 2 p.m. I host a question time. It's obviously not the PM's question time, it's regarding party wall questions. So please send your questions in and let's get going. Today's going to be a quick session. We're going to have to finish on time. Got another course to attend. Right. Okay, so it's all about your questions. You can send your questions in. If you're on a phone, they'll be at the bottom. Various other devices, you'll find them somewhere. Raise your hands, send your questions in. And this is what the show's all about. It's all about your questions and how we answer them, and how we help you move forward with the party wall process. So we are live on YouTube. I'm just watching it coming in through the other screen. Quick announcement. We're looking for architects to come on our show. We can help them answer their questions and help their clients answer more questions and deal with the issues regarding party walls. And don't forget, the important part of the act. I'm going to get my magic spotlight out. That's it. So it's this little three or four letters, 3 letters, 4 characters, if you like. It's the etc. bit. So everybody always believes, and a large number of people I speak to believe it just concerns the party wall, and it's just the wall. It's actually much more extensive than that. It is about excavations, cutting off, projections, if that makes sense, and various other issues to do with supporting adjoining owners' land and how way construction is done, including access to neighbouring land. So these are quite important, these 3 letters, and the Party Wall etc. Act refers to more than just the party wall between neighbours. I thought I'd emphasize that, and it's just come to mind. So looking for architects to come on the show, please send your details in. You can connect with me on info@1996partywall.co.uk or on LinkedIn. And as per my introduction, I'm the Chief Surveyor, but I also quite enjoy talking about party walls and try and help you with your issues and questions. Okay, so let's get going. So I've had a number of conversations over the past week with real life people coming across difficult issues. One couple in particular, and I spoke to the wife, trying to do a loft conversion, and part of the problem is there are some difficult questions that need to be raised and asked. So here's my little take on difficult questions that you need as a homeowner, that you need to homeowner / property owner, that you need to understand. So what would I think are the most difficult questions that people need to ask and understand? And as a profession involved in the construction process, you may not have the answers, but these need to be raised. So you need to understand as a property owner how notices are served. The Party Wall Act is one of those laws that although you can ask people to help you and you appoint surveyors and so forth, it's you that carry the responsibility in the end. And there's various issues that go on that mean you're still actually responsible for your surveyor's action, not least including fees and going to court and so forth. So number 1 question to ask and understand is how are party wall notices served? And I'll put a brief answer there, which is certificate of posting. And the reason for this is actually left out of the current government literature available. I'm going to come to that later on. And I'm not having a go at the literature. Actually, the literature is very, very good. It does explain a lot of the other issues covered. However, it is weak. It is slightly weak on this issue of how notices are served and the need for a certificate of posting. And it all fits into further on, as I'll go through, something called the 10-4 process, and that's where the neighbours don't respond to your answer, to your notice. hopefully this will all fit together as we progress. What happens if the neighbours do not reply? So that this leads on to part of this. If the neighbours don't reply, you need to proceed through the attend-for process. So 2 fallacies. You can't start works if your neighbours don't reply. And secondly, your neighbours can't stop you from doing works, especially by not replying. So those are 2 important points to note here. These are 2 incorrect beliefs, and sometimes we come across them by professionals. 100%, you can't start works if the neighbours don't reply. Also, neighbours can't frustrate your works by not replying. And sometimes people think they haven't given us permission. They actually don't give you permission. All they're entitled to do is to appoint a surveyor on their behalf. And the 2 surveyors go through the process of, and the phrase is something like determining the time and the manner of of how the notifiable works are conducted. And they do that by a process of a party wall award. Third question to really understand and get your head around, and this is, you know, I'm coming up to nearly 13 years in this profession. This is a question that's still hard for for building owners to understand, and the definitions will come up shortly, is that it's potential adjoining owners, surveyors' costs and adjoining owners' costs that you need to worry about. They always ask for our fees, and we're quite happy in some circumstances, in actually most circumstances, do a fixed fee basis. But what we can't predict are the adjoining owners' surveyors' costs and the number of adjoining owners. So that will come to later on. So this is all these questions sort of breaking bad news, but this is probably the worst. And if you're talking to a professional in the industry, you're trying to gauge a party wall surveyor, if they don't have a go at explaining this to you properly, they perhaps are not sure of the process or haven't had enough experience of coming across this and how this process works. So, and this is the most difficult issue to explain out of everything that occurs in the party wall process. And my approach is always plan for the worst and a bit more than hope for the best, but hopefully it lands somewhere in the middle. Now, for most people these days, what's even more important than the costs, and it's fast becoming so, are timescales. Increasingly, people are having to work at home. They're confined in their homes. We've been through this unfortunate lockdown for 6 months. It's in calendar basis, it's almost a year, because the building seasons during the summer, a lot of this year's building season has been missed. And where you've got younger families or families that get coming up with children that are growing up fast as they do, timescales become important, and this was the reason for the call. And this prompted me to go through this again. I've been through this before, but I'm just doing it for to re-emphasize the timescale of the party wall process actually depends on your neighbour's reply and how they proceed and what they choose to do and the choices they make. But generally, I would say it could take anything from 1 week to 3 months, and it's just dependent upon the adjoining owner's responses, i.e. your neighbours. And I'm going to explain the formal process, but too often people will look at the notice and say, well, this is a section 6.1 notice, it's a 1 month notice period. Yeah, after this you'll be in a go position. That's not actually true. Or if you're doing a loft conversion, they'll look at the notices, it's a section 2/3 notice, it's a 2 month notice period, and they'll say, yeah, you can start in 2 months, or if we can get it across, because the 10-4 process can actually finish in about 43 to 45 days. If we can finish the 10-4 process, you can proceed. Actually, that's not entirely true either. Sorry, they think once an award's done, they can proceed. That's not entirely true either. So my approach, and probably 99.9% of the cases, this has worked. There are very occasional works, and And those have all fallen into, I actually only know of 2 occasions where the notifiable works haven't proceeded as intended. One of them was a commercial building, and the second one was a scenario where the neighbor had asbestos in the chimney. So, you know, this is something to watch out for. Most party wall processes you're going to go through, but it's the cost and the time scales that you have to configure for. So let me put some detail on this. Okay, so let's start with why you should take the party wall process. Well, forget the fact that it keeps me in a job. It's actually the more important issue is it is the law, and it's your responsibility as a building owner or as a property owner to undertake the party wall process prior to work starting. So it's not the architect's responsibility, and it's not the builder's responsibility, and it's not the project manager's responsibility. It's one of these laws, very much like health and safety, that the buck stops with you as a property owner. So bear that in mind. It's your responsibility, and you have, and the fact that you actually don't understand the process and all the nuances doesn't actually mitigate from that responsibility. So make sure you understand, as a person who owns a building that's about to have works done, the legislation and the responsibilities it lays on you. Now, one of the other reasons for taking the party wall process is that it enables you to take a schedule of condition of the adjoining owner's property. Now, that's not always, that's actually for your benefit, i.e. when you do a schedule of condition on your adjoining owner's property, you've got their condition logged, so that they can't blame you for damage that already exists. And my favorite example, as I've been through it a number of times, is whereby did a survey on someone's house in the passageway, asked his wife, because she was at home, if he had any leaks, and she said, yep, just above your head, the bathroom leaked, and there's a watermark. And so I took the photos, put it down on my survey, carry on. And when I sent the report to the owners, the husband rang me up, and he's quite angry, and he said, listen, what are you talking about? There's no water damage in my house. And he said it with such certainty, and I thought, I've got this wrong. I've mixed up the files. There's something wrong there. Let me check. So I checked through, found the photograph, and then I remember the conversation, and I sent him an email with the photograph in there. And at that point, we weren't doing photographs loaded to hard in the cloud. So I sent him the photograph, didn't hear back. So it just makes you think, and we have come across lots of circumstances where the adjoining owners become oblivious to the damage they've got in the house, because look, we go through it each day, we forget about it, and it just sort of doesn't register in our mind. And then when you're doing works, your neighbors are going to start looking closely and examining their building for cracks and so forth, and they're going to try and probably without trying, you're possibly going to get the blame, or possibly on purpose with false and malicious allegations. So to protect that, you have the schedule of condition to protect you from false and malicious claims. Now, the other thing that can happen is your project could end up being stopped midstream while the party wall process is cleared up. So I've had this on a number of occasions. It's not very good for you. It's not very good for us. And it does end up taking more time and costing you more money than if you'd done it in the first place. So my reason for always saying to people, get it done first, is you don't want to be in this scenario. Okay. And connecting to that point, it's cheaper to do it before the works begin, and the sooner you start, the better it is, because it gives us more time to work on a better outcome for you. Time is our friend here, so the sooner you can start, it allows us to be flexible, to answer the questions of the adjoining owners, to answer the issues that the adjoining owner surveyors can bring, and it's time is a friend in more sense than one, in that if the adjoining owner surveyors on most occasions are creating difficult questions, it gives us more time to argue with them and not to come under pressure and accept higher fees than necessary. That's a little insight into the industry, but definitely it's always better to do these things in advance. And finally, but not least of all, you don't want to be in a scenario where the neighbour takes legal action because you haven't done a party wall process, including all the points above. But here, the courts will probably go against you by not doing the process, and the judges aren't happy about people disobeying the law. They don't like the excuse, I didn't know. And also, you're going to have to go through the process anyway, so you might as well do it to start with and save the legal costs, which aren't always recoverable. So just really to emphasize the 5 points, and wrapped up in this 5-point sandwich is it's the law. So your responsibility, schedule of condition protects you, stop the project from being stopped midstream. It's cheaper to do it before, and it stops legal action being taken. So let me put across the building owner's perspective. And here what I've tried to do is, if you try and read the Act, it's all about walls, foundations, excavations. It doesn't actually relate to projects as such. So I've tried to put this little chart up whereby we're looking at different types of projects that occur regularly on our street. So if you look out, you'll see a couple of these going on: rear extensions, loft conversions. Everybody's favorite is removal of chimneys, but this one absolutely drives me mad, because this is the second most risky type of project next to basements. Basements usually in higher value areas, and very rarely we get porches that are notifiable, but we do have to have a mind open to it. Now, here's the crux of the party wall process. So, and I guess out of all the slides I do, this is probably one of the 2 most important ones to understand. So stage 1 is started by the building owner, where the building owner gives the adjoining owners notice of their intention to carry out notifiable works. This is not a party wall agreement, and a number of times, I really wish I had a pound for every time I hear someone say to me, we sent a party wall agreement, they haven't signed it, what do we do? So it's not a party wall agreement, it's simply a notice for your intention to do works. It's served by the building owner to start the process. Now, I say served by the building owner, there's a number of ways you can do it. You can employ a surveyor to do it. And the reason I recommend that is the process is actually quite complex. But if you are gonna Google it, get the notices of the internet and do that, that's fine. All I'll say is use our notices, because the ones that are in the sample ones in the government booklet are quite confusing for those type of simple works. If you're not doing something residential, i.e. rear extension, loft conversion, chimney, I wouldn't do a basement myself, and a porch maybe. Then if you're doing those type of works, by all means use our templates, and they're freely available. We'll give them to you for free. There's no charge for them, because, and I'll explain later, there's actually a process set out whereby what happens if you don't get a reply from the neighbour, from your adjoining owners, and that's sort of lacking in the government leaflet that they give out. So second stage is decided by the adjoining owners. Now this is a super important point to emphasize here. It's decided by the adjoining owners. This affects the time scale and the costs involved. So again, just to recap, so they could opt for a schedule of condition which protects both sides, and it protects building owners, especially for false and malicious claims. So there's no arguments of what pre-start baseline. An award is simply actually the party wall agreement. So when people talk about an award, that's the party wall agreement. So that people say party wall agreement, what they're actually talking about is an award. This is a legal document which sets out rights and responsibilities of both parties. and it also contains procedures if there's dispute. So it's a dispute resolution procedure. So just to recap, stage 1 is started by building owner. Stage 2 is decided by the adjoining owner. Now the basic terms. So you've heard me talk about building owner, adjoining owner. So the building owner is the party that wants to do the work. So that would be you as a building owner, if it's your house. You could also be a leaseholder wanting to extend their house. So it could be a leaseholder wanting to extend their flat, or a leaseholder wanting to do commercial flat, works, all of those going on. So how does this proceed? So adjoining owner, on the adjoining owner side, there's multiple classes. So there's first of all freeholder. So if you're in a terrace house, for example, and there's a whole bunch of videos that explain this further. But if you're in a terrace house and you're doing a rear extension, your potential adjoining owners are to left and right. Could even be more than that actually if you're excavation and there's the adjoining owners are quite close. So it's all dependent upon your work. So there's freeholders that are notifiable of the adjoining owners. There's leaseholders, and this is leaseholders of more than 1 year. So it's not the AST tenants, but with commercial buildings, you often leaseholders between 1 and 7 years are missed out because they're actually sometimes not picked up on land registry. So be aware of that if you're in commercial premises. There's also a group of people that have rights to receive profits. This could be trusts or people who have right to receive profit, and parties that are they're under some sort of lease purchase agreement and lease purchase options, so forth. So bear in mind that they're also notifiable under the Act. And finally, but not least, and this also catches a lot of people out, we have people who are contracted to buy land. These are the guys that can that include. So contracted to buy land. This occurs where we're given a notice, and the next door neighbor says, "Well, I don't care what you do because I've sold the house or I'll put it on the market." Now, if you're contracted to buy land, the minute they exchange, they become notifiable owners. And if you've sent it to the previous owner, they're still notifiable, and it makes sense because if the damage occurs, it's to their property, and so you're going to get caught up by the change of property. So be aware of that, and any adjoining owners need to disclose if they've under conveyancing. They need to disclose if there's a potential party wall dispute, and this counts as a party wall dispute. It's a technical dispute, as they'd say, but it's not. It doesn't mean you're in a dispute with your neighbor. But so if your neighbor is selling, you need to be aware and engage with the new buyers as soon as possible. That's the shortcut of it. Okay, so notifiable under the Act. Let's have a look. Sorry, lost my train of thought there. The process for each adjoining owner. So what can happen? So you can consent with a schedule of condition. Your neighbors can consent. Each of the adjoining owners can do one of, it's usually 3, but there's actually 4 scenarios here. They can consent with a schedule of condition. And as I said, schedule of condition is where you do a survey of their property prior to works to get a baseline just in case there's damage. They can also dissent to the party wall notice, and they can use the same surveyor as you or have their own surveyor. And here, if you've got 2 adjoining owners, each one could do something different. And an agreed surveyor can act for both sides on one adjoining owner, and on the other adjoining owner, it could be either a schedule of condition or they have their own surveyor and your surveyor is acting with them. So that's a bit of a split there. So we've illustrated it in this manner. But for residential works, the output's exactly the same. In fact, in all works, it's the same, but there isn't that much extra adjoining owner surveyors can provide. In case of basements, we're not allowed to be the agreed surveyor, but other residential works, it's probably recommended. And the outcome is that you get a schedule of condition and a party wall award. So away we go. Now, if there's no reply from the neighbor, they have to go through a 10-4 process, which is send a reminder letter out. And if they don't respond to the reminder letter, the surveyor appointed for on their behalf can send them a letter requesting a schedule of condition. We're not allowed to demand a schedule of condition, although that might be changing shortly. And basically, there's a party wall award that's created. There is a request for schedule of condition, but you're free to proceed works without that. And if they request a schedule of condition later on, that takes place later on. Okay, so let's do a quick run through of the 10-4 process to get some more meat on the bones, as if it were. So once you issue a notice, and remember, personal recommendation, give it to the neighbors, put it in the letterbox, and post it via certificate of posting. I'm going to say that again, post it via certificate of posting. So that's the 2 days are extra to give you allowance for certificate of posting. If you receive no reply, need to send a 10-4 letter. Although it says 10 days, you need to add an extra 2 days for certificate of posting. We're running a total of 27 days here. And after this period, if they've not responded, then you need to appoint a surveyor on their behalf. Now, it can't be your same surveyor as you, so you can't have an agreed surveyor here. They have to have their own separate surveyor, and their surveyor who acts on their behalf requests a schedule of condition. There's no time period set out as such. Normal practice is 10 days. We can trigger it off in a week. So up in this point, we're up to 38 days. And once they send this letter out, normally you serve an award within 5 days. And at day 43, you've done the 10-4 process, you are good to go. However, if it's a loft, you still need to wait 2 months, because recently I had some training with a barrister and Stuart Frame, and very kindly put this question to rest. Yes, unless they agree in writing, you have to wait the 2-month notice period in case of lofts and chimneys. For rare extensions, it's 1 month. So don't be fooled by this 43 days, but that's the minimum to go through a 10-4 process. If the 10-4 process isn't carried out, and although I've been explaining it for years, I hope people are understanding it now, but not necessarily, because I still get calls saying, we haven't received an answer, what do we do? If you don't carry out the 10-4 process, this may result in no survey of the adjoining owner's property. If you're the adjoining owner, engage in the 10-4 process. It doesn't do you any good to sulk and not engage. And if you're a building owner, it doesn't do you any good not to appoint a surveyor. It might cost you extra, but then again, it stops you having to stop your works while all this stuff gets sorted out. So I was previously asked for a wording of a 10-4 letter. I'm not going to go through that now. Might have to do it on another occasion. So here's a little wording of a 10-4 letter. More information. So good booklet. However, not very good for serving notices. The example notices aren't very good, and the other procedure isn't there. Whereas just to cover it, and what I'm going to say once more, great booklet for information, but you need to read it in conjunction with our little booklet. Ours is a much smaller pamphlet, freely available. I'll send it to you. It's probably on my LinkedIn anyway. And there we set out a process for how to serve notices and make sure you do the 10-4 process. So hopefully that's useful to you. Make sure you get the process right. One of our sponsors, I think I mucked some tech up, was trying to ring me actually. It's Ranjit from Property Investor News. If you don't already invest, super great magazine, monthly basis, talks about everything that you need to know as a property investor. They've got a really great deal. They'll also give you a free book. And one of our other sponsors is Rent Kitchen. So if you're doing a project with rear extension, contact Sanjay. Here's his details. Send him your proposals, and he'll do you a really great plan for doing your kitchen, adding value to your client or your own property. So once again, thank you for your show. Thank you for being here. Thank you for your questions. Really great questions coming in. Keep them coming in, and I look forward to seeing you next week. I'm sorry, I'm going to have to dash off today. Got to go jump on another call. So thank you very much, and I'll look forward to seeing you next Tuesday.